Hi, everyone. My name is Arjun Sethi. I co-chair the Committee on Homeland Security, Terrorism, and Treatment of Enemy Combatants, the Criminal Justice Section. Thank you so much for joining our CLE panel this morning/afternoon, GITMO 12 years later. I am so excited that we have such a distinguished panel of guests with us to discuss their breadth of experiences working on this issue, really going back many years. I want to thank Carol Rosenberg, Rick Kammen, and Pardiss Kebriaei for being here. I sometimes feel that a lot of the advocacy regarding Guantanamo and the coverage regarding Guantanamo, it's a thankless job, and it's underappreciated, and it's difficult. And again, I want to thank everyone for being here, and the panelists especially for their service going back many years. Two quick announcements, and then we'll get right into introductions. One, I have been told to tell you all, when you sign the CLE sheets in the back, please do not take them with you. They are supposed to stay with us in here. Second, please know that we did our very best to get a representative from the government to join this panel. David Ribicki, who is with the Department of Justice, initially confirmed. He had a conflict. We reached out to numerous other government officials asking them to join. Unfortunately, no one was able to attend. In my opinion, hopefully that portends a change in policy. But of course, that is very unlikely to be the case. Rather than reading the biographies of each of the distinguished panelists, I'd actually just like them to maybe spend 90 seconds introducing themselves and just talking a little bit about how they got here. Why don't we just go ahead and just go down the road? We can start with Carol, move to Rick, and then go to Pardiss.
I work for the Miami Herald, which is owned by McClatchy, and after the 9/11 attacks, my newspaper decided that if the U.S. government was going to put a prison and later a court out of reach of the American people, they would make sure it would not be out of reach of American journalism. And they sent me down, and I had a very prescient editor who sent me down and told me not to come back until it's over. So when you look at the thing out there that says Guantanamo 12 years later, I believe it's, for me, Guantanamo 17 years later, 16 years later. And in short, we cover all aspects of Guantanamo as best as we can through the Miami Herald and McClatchy webpage, Twitter, and I hope you guys will start paying attention if you haven't.
I'm Rick Kammen from Indianapolis, Indiana. In 2008, my law practice consisted of sort of a weird mix of federal capital cases where I was appointed to represent people around the country, and then what I refer to as stupid stuff rich people do. And I was recruited by the American Civil Liberties Union to be one of the death penalty lawyers as part of the John Adams Project. In 2008, the rules in Guantanamo did not contemplate death penalty experts being necessary, and the military lawyers don't have experience with this, so the ABA recruited us, myself and 5 other people, to be part of this and to help the military. And for a lot of reasons, I ended up staying on as counsel for Abdul Rahim al-Nashiri from 2008 until about a year ago, and we'll get into the circumstances under which I have kind of left the case, in a little bit more detail. But that's the basic story of how I came to be here.
Hi, I'm Pardiss Kebriaei. I'm an attorney at the Center for Constitutional Rights, which is a group in New York. I started there in 2007, coming from a field of international human rights. 2007, by that time, even President Bush was saying that he wanted to close Guantanamo. So I literally had a conversation with our executive director about the tenure of my job. I thought I'd be out of a job in a couple of years. It'd be a 2-year stint. It's now, 11 years later. and I'm still there representing people as I have been with my colleagues for, CCR brought the first case in 2002 on behalf of detainees, so we've been doing it for a long time. I've been doing it for about 11 years.
Thank you so much for the introductions. Why don't we start with you, Pardiss? Maybe you could tell us a little bit about sort of the genesis and the evolution of your work at Guantanamo and the recent legal challenge that the Center for Constitutional Rights just recently brought on behalf of numerous detainees at the base.
Sure, Arjun. And I just want to say thank you to you and to the Criminal Justice Section and the ABA for holding this panel and the ABA's work throughout the years on this issue. As you said, it's now an issue that very few people care about or talk about, so I really appreciate the opportunity to be here. I realize, looking at the audience, that a lot of what I'm going to say in terms of background leading up to the present moment and the present litigation is going to be really familiar to some of you, but maybe not all of you. So I will talk about just background context and the different twists and turns our advocacy has taken over the years as a way of leading up to where we are now and the litigation we've brought now. And I thought I would just do that by way of talking about some specific men that I've represented in their stories and how they've sort of illustrated different moments in the prison and of the work for them. One of the first, like I said, I started at CCR in 2007. That was 5 years after my colleagues had been litigating these cases just on the very basic question of whether we could get into court. That was a question that wasn't resolved until 2008. But when I first went down into the prison, one of the first men that I met was a young Syrian man who was captured in Pakistan when he was about 17 or 18 with his father and transferred to Guantanamo and held without charge until his release ultimately in 2009. When I first met him, Boumediene had been decided. This was after June of 2008, so the right to habeas had been established, again, after 6 years of litigating that question. Habeas petitions that had been filed in 2004 and 2005 after the first time the Supreme Court said detainees had the right to habeas in 2004 in the Rasool versus Bush case. Habeas petitions had been filed but stayed. And finally, when I started going down, stays were being lifted. Cases were really slowly kind of creaking forward under this mandate that detainees were really now entitled to prompt and meaningful habeas hearings. In the first years, the majority of habeas petitions resulted in wins for detainees. The cases were sort of falling apart under judicial scrutiny, even under procedural standards that were less than what we had asked for. So there was litigation activity, there was momentum. The first meeting I had with this individual, we did what lawyers do. We talked about the facts of his case and what we would say, what we'd argue in court. And it wasn't just about sort of sustaining him, which is what the work has largely become since then, but there was active work going on the habeas side. This was on the cusp of the Obama administration, not yet in office, but a candidate for president. There was momentum around that. There's obviously this famous or infamous executive order on his second day in office mandating the closure of the prison. When he came into office, mandated a review of everyone who was being held in the prison at that time. There were 242 men at that time. Mandated an executive review of their detentions to resolve those cases as, in terms of men who could be cleared for transfer, men who would be referred for prosecution, and then men in this now problematic third category who remains in sort of the legacy of Guantanamo of people who couldn't be charged or released. But we were very much on the same page with the administration, and all of that litigation and being on the same page with the administration, there was certain energy and urgency and emergency around the prison because conditions in Guantanamo were also quite different at that time. The majority of men back in 2008 when I first started going down were being held in conditions of solitary confinement, whatever the government wants to call it. It was 22 to 24 hours in a cell. That was the majority of people in prison at the time. The man who I saw in his early 20s, held in those conditions for the duration of his detention. There was a review of conditions of the base by Admiral Walsh, by an official in the military at the time, to sort of review conditions at Guantanamo and determine whether they were Geneva Conventions compliant. And we, lawyers and advocates, had a long list of demands for improvements in conditions. So there was a more sort of palpable and overt, I think, emergency at the prison at the time when I started going down. That's what it looked like in the first, my introduction to Guantanamo was really that. Litigation, an administration that wanted to close the prison, and a real emergency. Go from there to another key client I represented in 2010, a young man from Yemen in his 30s, who had the dubious distinction of being the first case the D.C. Circuit issued an opinion on, a case called Al-Bahani versus Obama, where the panel decision rejected the relevance of international law in interpreting the scope of the government's detention authority. By 2010, the appeal, the D.C. Circuit's decision in his case, started a pretty uninterrupted series of cases, line of cases from 2010 into 2011, where the D.C. Circuit reversed or remanded every habeas grant in the district court and affirmed every denial. So pretty consistent line of decisions that by mid-2010, had made it virtually impossible for detainees to prevail on the merits. And by mid-2011, had really ground habeas proceedings to a halt. So that's a very different environment than when I first started out. And the work at that point, in terms of litigation, really, we had hit a wall. But we were still on the same page, theoretically, with the administration. So the work shifted out of court, in large part, to advocacy in the public, pushing the administration, which now sort of seems quaint. We did a lot of, our talking points were, Obama doesn't have the political will to make good on his promises. We did a lot of advocacy for men who had been cleared for transfer by the Obama administration's task force. And there was a lot of work with the periodic review boards, which were administrative mechanisms set up by the Obama administration in 2011 that took a very long time to actually start, despite the order in 2011, but that reviewed the cases of men who had not been cleared for transfer by the initial task force, reviewed their cases to see if they could be cleared and transferred out. So a combination of advocacy, the PRB work, and then, frankly, detainees taking matters into their own hands. In 2013, there was a prison-wide hunger strike that I think is actually ultimately what got Guantanamo back on the administration's agenda and made it a priority. So, between 2013 and 14 and the end of the Obama administration, there was a lot of activity and again, a certain momentum in releasing, clearing and transferring men out. Dozens of men in the final years and months and weeks and days of the Obama administration. And in fact, the man that I was talking about, Ghalib al-Bahani, the Yemeni man, was transferred January 16th of 2017, just days before Trump took office. So literally until the final hour of the Obama administration, transfers were happening. And I guess here I'm just going to pause for a minute and do what I usually don't do, which is be positive about Guantanamo and the work that, what we have achieved. I think we, meaning lawyers, the ABA, journalists like Carol, advocates, the men themselves, in breaking through barrier after barrier in court, in terms of secrecy in the public, and reducing a population of nearly 800 to 40 people. I took a trip down to the prison right at the end of the Obama administration, beginning of Trump, and it really felt to me, and I'm curious to hear what Rick and Carol have to say, kind of felt to me like a ghost town. I mean, we drove past camps where former clients had been held, and I was sort of remembering having visited them. So despite the rhetoric of Trump and bellowing about filling the prison back up, it really felt like the end of an era at that time. I think things are different now. And again, curious to hear what Carol has to say about, construction and all of that happening at Guantanamo, and talk of brothers growing old together, as the spokespeople for Guantanamo are saying. But so that brings me to the present, which is with respect to a man I represent now, his name is Scorched-Earth Al-Hajj. He has been held without charge at Guantanamo since 2004. Before that, he was in CIA sites for 2 years without charge, brutally tortured. Some of the facts of his treatment are unclassified in habeas papers. He filed a habeas petition in 2005, like most people. It was stayed, and he ultimately withdrew it himself voluntarily in 2010 because it was clear that under DC Circuit precedent that has now been set and sort of entrenched, there's no chance he would win. He's someone the government accuses of being a facilitator for Al-Qaeda. This is in relation to a standard for detention authority that sanctions, indefinite, potentially lifetime detention on the basis of staying at a guest house, traveling a certain route in Afghanistan, having certain associations, really tenuous associational conduct. Now can authorize detention under the domestic statutory basis for these detentions, the 2001 authorization for use of military force. So given that, there's just no chance that he would win on the question of whether he was part of Al-Qaeda and detainable under the AUMF. So he withdrew his case, and so until recently, there was, we were scratching our heads as to what to do in court for him. In terms of the administration, clearly, we are not on the same page. I think in word and deed, we believe the administration has made clear that it has no intention of transferring any detainee. It has issued an executive order reversing the Obama administration's mandate to close the prison. It has shuttered the offices of envoys who were tasked with transferring detainees. There has been no detainee transfer in the year and a half that President Trump has been in office. And the PRBs, the one mechanism that exists for clearing men, have really become meaningless. So that's sort of politically where we stand with the administration. And so what all that means for Scorched-Earth Al-Hajj is that he is facing at least another 3 to 7 years of imprisonment on top of the 16 he's been in under this administration, and then who knows how much longer under another administration. And what it has meant for us is, again, needing to think hard about new questions to raise in court. And that brings me in the minute that I now have left. We can talk more about this because it's a long panel. But the petition that we filed on behalf of a group of detainees, 11 men, that is asking the question of putting aside the argument with the government about whether there was ever authority to hold men under the AUMF, whether they were ever part of Al-Qaeda. Let's say they were. The question we're asking today is, does that authorize perpetual, potentially lifetime detention, or is there some durational limit that the law imposes, the Constitution and the AUMF imposes? And if there's not a finite limit, doesn't it at least require more robust process than these men have been afforded? We're talking about indefinite detention on the basis, for men who have never had criminal process, on the basis of a preponderance of the evidence, which is unprecedented when you look at non-criminal detention jurisprudence in the U.S. So we've argued for at least a higher standard of proof, clear and convincing evidence at the very least. But bottom line, we think detention can't go on indefinitely of this sort. That litigation is pending. There's in one case, Judge Leon of the District Court in D.C. has issued an opinion. We just filed a notice of appeal in his case. The remaining men, their petitions are still awaiting decision before Judge Hogan and Judge Sullivan. So it's tended to spend most of my time on this petition, but we can get into it in the Q&A. But that's where things stand now in terms of litigation.
Thanks so much, Pardiss, for providing that background and talking about the evolution of your work. There will definitely be an opportunity to expand upon the trajectory of the litigation and where it stands now. With that, I want to go ahead and move to Rick. Rick, you had mentioned your work with the John Adams Project and the recent circumstances under which you withdrew as counsel in a major matter at the base. So why don't you go ahead and just jump right in and tell us about those circumstances that I know everyone wants to hear all about.
Sure. By way of background, from 2008 till last year, I was the death penalty lawyer for Abdul Rahim al-Nashri, who was alleged to be the mastermind of the bombing of the USS Cole. I've handled about 40 federal capital trials throughout the country, and Guantanamo is a place that's unlike any other. You know, the way I would say it is the outrageous and ridiculous are commonplace. And within our team saying was, no sentence can begin with logic would tell you, common sense would dictate, or anything like that, because that just takes you to a hole of despair. And that really governed our litigation for, well, he was charged in 2008. The charges were withdrawn by the Obama administration, and then he was recharged again in 2011. And since that time, we have been litigating his case. In 2011, the government was asking for trial in 2012, which was ridiculous. But the judge asked us to submit sort of what we thought was a reasonable timeline, and I prepared a timeline that the military lawyers didn't want to file because they just thought it would just have no credibility, which predicted a trial in 2014. Well, here we are in 2018, and the Nashiri case is probably 2 years away from trial when it resumes. So that kind of gives you a sense of the legal goo that is Guantanamo. Nashiri was in the CIA black sites for 4 years. Some of what was done to him was referred to in various public sources, but I can tell you that that represents about 40% of the reality. The reality of what was done to Nashiri and the others is far, far, far worse than is commonly known. And the level of brutality and human experimentation is almost unimaginable. One of our experts who's been assisting us, Dr. Sandra Crosby, whose medical practice is treating victims of torture all over the world, has indicated that as a result of and I'm quoting her, the physical, psychological, and sexual torture inflicted on Nashiri, he is one of the most traumatized individuals she has ever treated. And she makes her living treating victims of torture. So Nashiri is an incredibly damaged and incredibly challenging, but in his own way, an incredibly charming individual. And so that's, you know, the sort of the backstory. The discovery in the case, I mean, to give you a sense of how weird Guantanamo is, in 2014, the judge ordered robust discovery about the CIA torture program. By 2017, the government was saying that they thought they could comply with the judge's order by the middle of 2018. So there has literally been 4 or 5 years waiting on discovery. And I will tell you that that discovery will provoke more litigation. The other thing driving the sort of overarching this, really since the beginning, has been intrusions into the attorney-client relationship. The two most commonly known or reported things are, of course, one time, I think it was in 2014, we found smoke detectors in the meeting rooms where we met with our client that really turned out to be microphones. But what was less commonly known is that we encountered a situation where the government was monitoring our usage of computers. All of the defense's emails at one point somehow migrated to the prosecution servers. And there was just intrusion after intrusion, and you know, mail being read. If you gave your client documents, they would be taken away and, you know, reviewed by people. And it was just one thing after another, which brings us to last year. In June of 2017, General John Baker, who's here, who I will say is really an undiscovered American hero, sent out a notice that we couldn't be certain that we had really were having private conversations with our clients yet again. We began looking into this, filing motions, doing things, and a wall of secrecy came down, worse than the torture. I mean, this was a wall of secrecy that was unlike anything we had encountered, which really told us there was something there. Well, one thing led to another, and ultimately we were allowed to do a more robust inspection of the room where we met with our client. And we found, and I can talk about this now, but for many, many months I couldn't, we found microphones. We also found some other stuff that is hugely significant that I'm not allowed to talk about because it remains classified. And so we were absolutely convinced by that and some other things that there was active, ongoing monitoring. Well, we asked the judge we needed to tell our client because we couldn't meet with him without an informed waiver, and the judge's position was no, because it's classified and you can't share classified information with your client. Well, you know, we asked for discovery and we need to know what's been going on and what's behind this. And the judge's position was no, you're not entitled to a hearing. And then he issued an order which remains classified, but which generally held, and I hope I'm saying this correctly, that unless you can show that it was the prosecution who was listening, as opposed to some other government agency, you really have no claim of a violation of the attorney-client privilege. Well, we really didn't know what to do. I've represented this man for 10 years, 8 years, 9 years. There was a lot of turnover. So I contacted Professor Eileen Jaroslaw, who's also here, and hired her to give me an ethics opinion. I have an obligation to my client. Our team has an obligation to the client, but we are under these circumstances. Now, we had to prepare a summary for her that was unclassified, and it took about a week to prepare the summary to give her some sense of what was going on so that she could then reach an opinion. And she did, and her opinion was that under the Indiana rules of professional conduct, I was obligated to withdraw. We then had to go to General Baker, who is essentially our boss and the excusal authority, and show him all of this, and he did his own due diligence. And he concluded that we had shown good cause to withdraw and approved that. And one of the tragedies of this is that in many ways the notion has been that he didn't think this through and he just sort of signed off on it. And he did a lot of due diligence, and we did not know what his position was going to be. Well, in any event, we withdrew, and there's a conflict as to who has the excusal authority, the chief defense counsel or the judge. And so that immediately provoked a fight because we were ordered to come to Guantanamo, myself and 2 other lawyers. Our position was, no, I don't think so. And so General Baker was ordered then to appear in court and was ordered to rescind the order and get us on a plane and come down there. And in an act of really remarkable courage, his exact words was, no, sir, I'm not going to do that. The next day, he was held in contempt in a proceeding which you have to read to believe, because at one point he says, Your Honor, I'd like to say something, and the judge's position was, no, you can't. Well, ultimately, he was sentenced to 21 days in a trailer in Guantanamo, where his house in Guantanamo. That was quickly set aside, and
they're still monitoring, obviously.
No, that's my own monitoring, my own censor. And so, long story short, after 3 months in which the government, the judge proceeded to present evidence where the only lawyer Nashiri had was a Navy lieutenant, a very young lawyer who had never tried even a homicide case. And he was in the well of the courtroom essentially taking the position, I need learned counsel, and the judge was forged ahead for 3 months and held some pretty significant hearings. In any event, in February, the judge abated the proceedings, basically said, somebody's got to tell me what I can do to put lawyers in jail. So the case went to the Court of Military Commissions Review, a court in which the prosecution has never lost in the history of that court. And a couple of weeks ago, they issued a ruling that said, yep, there was no good cause, there was no real intrusion here, nothing to see. General Baker didn't have excusal authority. Mr. Kammen, you really are still Mr. al-Nashiri's lawyer. So, you know, when hearings resume, plan to come on back. And then there are future appeals. Last point, and then I'll quit. Overarching all of this, we learned during the pendency of these appeals that the military judge who created all this havoc, at some point, probably last year, who knows, had applied for a job with the Department of Justice as a immigration judge. And so during all this time, the best case is he was in negotiations with the Department of Justice to be an immigration judge upon his retirement. And that case is pending on a writ of mandamus before the DC Circuit. The CMCR said nothing to see there, and that case is pending before the DC Circuit on a writ of mandamus. So that is the 10-minute version of a 10-year odyssey.
Thanks so much, Rick. Again, there will be plenty of time for questions at the end. Thank you again. Carol, why don't we go ahead and move to you, knowing that so much of the progress we've made at Guantanamo, as Pardiss described, is because of transparency, and it's because of the sunlight that you have helped draw to a lot of the cases and the challenges that you've seen firsthand at the base. So maybe you could tell us a little bit about your work and your time there and some of what you're seeing today.
Okay, but can I just do one little chime in, which is,
sure.
In the Nashri case, the prosecution is not just military, but Department of Justice attorneys, so that we're all waiting to find out if, in fact, at what point, as a reporter, I'm looking forward to being able to report whether or not this judge had applied to the Department of Justice for an immigration court position at a time when he was presiding in this capital trial with DOJ in the prosecution.
And FBI.
Well, and FBI. And, you know, possibly CIA, but. So, as I said at the beginning, we cover all aspects of Guantanamo. And so we do cover I do cover the commissions. And I have to start off by saying, my newspaper has sent us down there, or me down there, and during the period when I was banned, somebody else down there, consistently since they started commissions, which, if you think about it, is an extraordinary commitment to a story most people don't care about. You see, I get a little emotional about it because I don't think people realize that the American newspaper industry has kind of imploded in the period of Guantanamo. And it almost makes no sense to send a reporter down there over and over again. But I go back, and I want to go back because I think this is an important story. I don't know how much transparency and sunlight we shed on this story, but we ask the questions, and we tell people what's going on that we see. The people with the security clearances who tell me that, like, we only know 40% of what's happened to Abdul Rahim Nashri makes it incredibly frustrating to be a reporter down there. because, you know, what we report is what's unclassified. Or in a few instances, when I wanted to do a little chime in that Rick can neither confirm nor deny because he has a security clearance, and anyone who knows is that based on my reporting, as I understand it, the precipitating episode that caused them to walk off the case with permission of the general was when they went to inspect, and he can't even like nod because when they when they went to inspect the meeting room, what I was told, based on I think credible, I mean I wrote it so I believe it to be credible, is that somebody had a screwdriver and they found a plate on the wall that didn't have a switch, and when they unscrewed it, there was a listening device inside it, and that when they walked out of sorry. I mean, I've never asked him, and he can't. And he's when they walked out of the meeting room and they went around to the wall behind it, there was a entire rig there that allowed people to be listening in. I said, you know, they were not having a meeting, but you know, like in TV, there'd be some guy there with a headset and reel-to-reel tape, and there would be a slam dunk. But we've reported it. You're not allowed to know it, or they're not allowed to confirm it. I found it to be just incredible detail that absolutely caught no attention. Possibly the best story, or the most, that's not right, the most impactful story I've had out of Guantanamo was when the judge put the general in confinement, which caught us a lot of attention. But the process of getting there and the process of getting him out and all of the different players inside this structure that's not a criminal court, not a military court, but some other court, to me is fascinating and incremental. And America really has no patience for the incremental. They want to know, is Guantanamo closed? They want to know, is somebody convicted? They want to know, is somebody released? Is somebody new coming? And that's not what we do. And so for commissions, we cover all of the hearings, and they can be pretty miserable and dismal. Those of you who've met me down there know that this isn't what I looked like down there, because I dress expeditionary because they put us in tents, and we shower in tents, and it's filthy and it's unpleasant. And so, you know, any effort to look like a business person went out the window a long time ago. So for this event, I got to take out my Yom Kippur clothes and come and talk to you, which is a treat, right? The push-pull of covering Guantanamo and commissions almost has, you can't necessarily link it to politics, and you can't necessarily link it to policy. When we first went down there, before there was courts, there was a interest in having reporters down there, and the tolerance by actually the Marine general who was running Camp X-Ray for questions, because there was a perception that we were all in this together. It was not long after 9/11. Attitudes in America were raw. They took these men, they put them on planes, they put them in orange jumpsuits, they shaved them, they shackled them, they put them on planes, they brought them and they put them in cages, and they told America, we got them. It was 4 months after 9/11, and everybody wanted to believe it. And the military perceived this as America's prison, America's enterprise. And reporters were there all the time. They didn't answer every question for security reasons, but they tolerated questions, they welcomed questions. And I remember at one point I said to them, what are you going to do if a hurricane comes? And the general said to his staff, you know, we should have thought of that question before she asked it. What are we going to do if a hurricane comes? Research it. So, you know, there was a role for the media that was meaningful as a representative of the American people at a time when Guantanamo was believed to be the right place, perhaps, that the people there were the right people, perhaps, and over time that eroded. I mean, I spent many years in the Middle East, which is why I ended up at Guantanamo, and I remembered looking at these men coming off the airplanes in orange jumpsuits and thought, they can't all be equally guilty. They can't be the right people. I mean, remember, there was no court then. It was this law of war detention, and I was like, 9/11 happened. How did we get smart all of a sudden 4 months later and get the right people? And so we actually brought a skepticism to the story that I think others didn't for a very long time. They wouldn't tell us the names, they wouldn't let us know who they were, and we dealt with anonymous people in orange jumpsuits. I'm going to do like 2 more minutes, which is when the detainees got lawyers, we got to tell a second side of the story, which was their stories. The men in the jumpsuits became people. They had lawyers who went down and talked to them, and we were allowed to know who they were. Maybe really bad people, but we were allowed to know who they were. Instead of being like assured by our military that these guys were all equally guilty, suddenly the grays became much more profound. During the Bush years, there were times when it was incredibly unpleasant to be a reporter, and there was times when it was tolerant. And it really is driven by the command climate. They change admirals out every year. The Pentagon climate, and currently, it is very difficult to get meaningful answers to meaningful questions, and I attribute that to the national political climate, which is people want things to be simple, and down there they don't feel any obligation to really give us sophisticated answers. What Pardiss referenced was back in June when we went down on a media tour. They put on a huge PR, public relations push for we, the reporters, to write about their desire to get $69 million out of Congress to build a new detention center for the former CIA prisoners. They wanted to build a new prison for the guys who'd been held by the CIA for 4 years, who have been held in their own prison apart from everyone else at Guantanamo. The press don't see them, the lawyers get to see them, but not in their prison. And the push was, we want to prepare a, what was the term they used?
Geriatric.
Hospice.
Yes, hospice, we called it geriatric. They called it hospice care. They wanted to be able to have hospice care cells where, thank you, where reporters could, sometimes it feels like, to be a reporter, it feels like being a detainee at GITMO, but where they wanted a place where detainees who were growing old and aging out and would be taken care of by each other. There's a man down there who's now in a wheelchair who's accused of war crimes, who's in a non-capital case, who's had 5 back surgeries, and can use a walker for apparently 12, 14 steps, and after that has to be moved around in a wheelchair. He's the first one. He's not the last one. There are people down there who are maybe not in the best shape, and I'm not saying the U.S. military hasn't done well by them. I think that in many instances they have. The lawyers for Mr. Hadi, who's had 5 spine surgeries, would disagree because they waited until he was incontinent in his cell to address the back. But they put on this big push. You would think that after the president said we're not closing Guantanamo and we're going to load it up, that new detainees would have arrived. None have. One left, a convicted terrorist who, in a plea deal, testified against his client, or former client, or future client, and was released after pleading guilty to being al-Qaeda and sent back to Saudi Arabia. So there were 40 detainees there. When Trump took over, there were 41. He sent one away. We should have a discussion about why new ones haven't arrived, because I think it has a lot to do with the nature of who they're picking up in the war on terror and this continuing debate over whether the authorization for the use of military force would cover ISIS, and whether that debate has changed since Justice Kavanaugh arrived on the court, and whether they might be more willing to find out whether putting an ISIS prisoner in GITMO. He hasn't loaded it up. It definitely is dismal there because of the sprawling infrastructure. I disagree with you. I think it's been dismal like that for, 15 years. Or that's not right. Since about a year into the Obama administration, there was more empty architecture and more empty prisons than full ones in it, and it didn't make a lot of sense. They could not get Congress to pay for this thing. Congress couldn't find $69 million to build this prison. Personally, I think that Congress should hold a hearing and ask hard questions about the future of Guantanamo if they're going to dump $69 million into it. They're not going to do that. I think one day I'll write a story that said suddenly somebody found $69 million and they're going to build that prison. But whatever we thought would happen with Donald Trump, hasn't yet. It's, pardon me?
Nothing.
No, I mean,
I disagree. I disagree. I think it's changed significantly.
We'll get into
that's
that.
fine.
Yeah, no, go
No,
ahead.
But anyways, as a reporter, it's harder to quantify the change. And we go back again and again. We have these hearings that, as I've told people, are in their second generation of judges. Two consequential things have happened since Trump took office. They fired this person called the convening authority, and half the room knows what that means and the other half doesn't, and so it would be hard to spend time explaining it. But the man who was in charge of military commissions was fired, and that has opened up so many questions about the future of the court and definitely slowed progress. And the other thing that happened is the chief of the judiciary, Judge Cole, Army colonel, who at one point was the presiding judge in his case but handed it off to the fellow Rick talks so fondly of, Judge Cole is retired. So we have brand new judges there who are really post-9/11 judges. And so commissions are in this place where everybody's trying to find their grounding to move forward. So everything's on hold for a series of reasons, not the least of which Rick walked out.
So I think you will all very likely agree with me that these weren't just presentations. These were testimonials of people who have put their bodies, minds, hearts, and souls on the line every day for work that they believe in, and in connection with advocating and drawing awareness to one of the most marginalized communities in the world, detainees at Guantanamo Bay. And while I ordinarily ask for applause at the end of the panel, given the gravity of what's been shared and given their immense contributions and given the immense contributions of the people in the room today, why don't we just take a second and thank them for their extraordinary work.
And please thank General Baker, too. Because
so I definitely want to leave time for questions. But before we get to questions, I would like to ask each of our panelists a question, and hopefully you can keep your response to 3 to 4 minutes, because I want to leave time for questions again. So Pardiss, maybe you can tell us a little more about the litigation and where you see it going from here. And maybe draw a little more color, if you have time, to, again, some of the additional challenges that you now face trying to bring justice to the 40 people still remaining at the base.
And what's taking Judge Hogan so long?
What is taking him so long? That's a good question. So on the litigation, I think the future of it is uncertain. We filed it in January of 2018, before there was a new Supreme Court justice, before Justice Kavanaugh was confirmed to the bench. The question of whether due process applies at Guantanamo and whether due process and the AUMF impose some sort of durational limit on detention was an open question that was raised by Justice Breyer, actually, in a statement denying cert in another case. So there were indications that we might actually, on the question of, on this question, have some success. I think that remains to be seen. I think it's in much further question now as we go up. This was always sort of a higher court, Supreme Court strategy that we had in mind. So I think there are serious questions about the future of it. It's clear that Justice Kavanaugh was he had an outsized role in the decisions of the D.C. Circuit on Guantanamo, was part of the al-Bahani decision, disavowing the relevance of the role of international law and interpreting the scope of the government's authority under the laws of war. So has had some hostility to international law, has been extremely deferential to aggressive claims of executive power. I think a question about the role of the courts in these cases is really in question. So I think for all those reasons, he is pretty as far as you could get from who Justice Kennedy was, who wrote the Boumediene opinion, the majority opinion in Boumediene. So we have questions about that. I think we have few options but the courts right now. You know, with the administration, again, nothing more needs to be said in terms of their intention, I think. The public, too, so much of our work since 2010 has been in the public sphere, advocacy. I think getting public attention and sympathy on 40 men accused of being part of Al-Qaeda in Guantanamo when you've got thousands of immigrant kids in detention facilities in these times is tough. You know, it's a question I think we're asking of priorities, and we're obviously in this work, we're going to stay in it, but we've got to keep reminding ourselves why it's important, and it's very hard to make the case, even harder to make the case to the public. I think in terms of what the advocacy looks like now, I was just thinking when Carol was talking of just secrecy, I mean, there's how much that has had to do still, despite all the information that we know, the Senate report on the CIA torture program, thousands of pages of how detainees were tortured and abused, all the reporting Carol has done. I mean, the stories we've been able to tell through the habeas cases, there is still baseline secrecy that exists and that really hobbles us in our ability to represent these men and do advocacy for them. For Sharkawi Al-Hajj, the man I represent now, who's part of this petition, you know, just basic facts about he's sick, he's on hunger strike, he's not well. I can't talk, you know, it's not just classification, it's these other levels of protecting information that come into play. So I can't sit here and talk to you about a motion we just filed with respect to his health, because the facts about his health and how much he weighs and his hunger strike and the conditions he's in are protected. So Carol can't go on the court's public docket and access that document right now until it is clear, some public version is cleared by the government. So, you know, just in terms of secrecy, facts about the men, facts about their treatment, about the hunger strike, about conditions at the base, all of those things continue to exist and really, I think, are so much of the reason why Guantanamo still exists today. It has constantly been, you know, the lawyer's word against the government, and we're not on equal footing, obviously. The government's word is always going to trump because we can't. First of all, Carol has no access to the men themselves. The public has no access, direct access to the men themselves. For 16 years, the only people they've been allowed to see are lawyers.
Even when we've gotten waivers.
They're jailers, right.
Even when we've gotten waivers. There are attorneys have taken, sorry to interrupt, but you know, I used to go through with Omar Khadr and with a number of people we wanted to interview, I would go through the drill or the exercise of asking the attorney to get a waiver of what they like to call down there their Geneva Conventions, which is this thing that they don't really necessarily understand, that they're willing to talk to me. And they've ignored the waivers by saying it's not in the interest of the good order and discipline of the detention center.
Right.
So we used to get waivers. But you don't talk to anybody. And sorry to interrupt.
Yeah, no, I think that's important. I mean, you get to see figures, you know, kicking a soccer ball or mingling in the communal part of a camp, but never face-to-face. UN monitors, you know, experts at the UN on torture who've made repeated requests over the years to try to meet with detainees and assess their conditions have been denied access. So I think all of those things, plus just the remoteness of the prison, you know, have just gotten in the way of being able to fully, in an equal way, tell a story. And it really continues today.
Thanks so much. I also want to encourage everyone to check out the work of the Center for Constitutional Rights if you don't know their work. They are an extraordinary organization that have been on the right side of basically every major civil rights issue going back a very long time. Pardiss knows how I feel about the organization, so if you don't know their work, check them out, support them, contribute to them. Rick, why don't you talk a little more about what you were just saying, about how you think things have gotten worse under this administration and some of the additional unique challenges that we face today when thinking about advocacy in connection with Guantanamo?
it was never good, but after the Trump administration really began to take hold, I thought there was a significant change in attitude, and the level of secrecy and the intransigence of the secrecy became, from the litigation standpoint, much, much worse. And that seems to have just increased over and over again. The other way it's become worse is they're using the secrecy to much more aggressively than the Obama administration did to frame the debate. For example, in our case, for months, everything about what we discovered was secret. We couldn't tell anybody. We just, were there. And then on appeal, the government took the position that the microphones we found were legacy microphones, that they'd been there forever and had nothing to do with anything. Now, they never made that argument in court. They never brought that to the attention of the judge. They never brought that to our attention, and I don't believe a word of it. Because while they declassified the microphones, they didn't declassify the other stuff we found. And so they've used it much, I think, in this administration, much, much more aggressively to frame the debate. And the final thing, from the litigation perspective, is that there was always kind of a scorched earth prosecution. To the point where we very often would ask ourselves, do these guys really want to have a trial? Because they were throwing up roadblocks that just made no sense. And if anything, that seems to have gotten worse before after the Trump administration. Whether that is a function of the fact that Gina Haspel, who, according to, I have to say this carefully, according to published reports, which I can neither confirm nor deny, was instrumental as part of the torture program, including, according to published reports, part of the torture of Nashiri, whether that's a result of her, sort of putting even more of a hammer down, whether it's just an institutional thing, I don't know. But from my perspective, there was a real change in the feel and the attitude after the Trump administration took hold.
Yeah, I could agree that the commissions have gotten more secret. I was talking more about access to the detention center and getting answers to questions being sort of a crapshoot when you deal with people at DOD. But next week, the 9/11 case is holding 2 or 3 days of secret hearings in Washington, D.C., the National Capital Region. They are having 2 days with the attorneys on both sides in closed session, scheduled for what they call 505H hearings, which is to game out what they need to do in classified sessions once they go down there. And they've reserved a full day at a secret site somewhere in the National Capital Region for the prosecution to tutor the judge who's just arrived on the case about the history of the secret evidence and SEPA-like substitutions that have gone on since 2012. When they have closed hearings like that at Guantanamo, I can at very least tweet it and point out that they went in at hour X and they came out at hour Y, so that there can be some sort of sense of how much is done in public and how much of this is done in private. This streamlining thing could have the effect of when observers go down to Guantanamo, they get 4 or 5 full days of hearings in public session because so much of it has been scripted in secret up in the National Capital Region.
Did you, Carol, you have a couple minutes if you'd like to make any final observations about what you've heard today or anything else you'd like to share with the attendees on your work and what you see as sort of coming down the pike?
Well, I'm just going to, I mean, I've sort of said it already. I think the biggest challenge is not the refusal to answer and the secrecy. For me, I mean, I understand they have a different, for me, the biggest challenge is declining interest in the story, because it's really easy to blow me off, because if people down there perceive that nobody cares about the answer. You know, there's 60 slots for people to cover military commissions, theoretically. I'm going down next week for a Hadi hearing as the only reporter. I asked questions of the Pentagon. You know, the White House, I haven't found the person who's in charge of Guantanamo detention policy. The State Department dismantled the, we haven't even discussed that, dismantled the office of the special envoy for the closure of Guantanamo. Well, it's true that Trump has no intention of closing Guantanamo, but the special envoy was also tending to cases of resettlements overseas, and they're inattention to the people who were released by both the Bush administration and the Obama administration is I think having consequences overseas, and stay tuned because I have actually a really good story coming out after the election on that. I hope. Inattention, disinterest is a problem. It is easy to forget about 40, in some ways, very unsympathetic people on a faraway island in a prison, and the run, by the way, I just have to throw this in, run by 1,800 people. We have a constantly revolving, rotating force of 1,500 troops and 300 contractors who run Joint Task Force Guantanamo, not the base, not anything else at Guantanamo, involved with the commissions, the trials, and the detention and the administration down there. And that churn, oh, this is a point I wanted to make. You know, they talk about when they sent them off to the CIA that they kept them incommunicado, did these horrific things to them, which have definitely been confirmed in declassified information, you know, tortured them, if you want that term, no access to the Red Cross, no access to attorneys, and they called it learned helplessness. Well, not to be sarcastic about it, but I believe that the 1,500 troops that come through there on 9-month rotations are also a product of a different kind of learned helplessness. They don't know their history, they don't know what came before, they can't answer questions, and they're not interested. I mean, in a way, the detention center military staff is a reflection of the American public. It's like everyone's just doing their thing. They go down there. I tried to get an answer. I tried to get an answer to what perks the troops are currently getting, and the man who's receiving the perks, as the public affairs officer said, he didn't know the answer. I mean, they're given separation pay, they're given and perhaps imminent danger pay, they're given different they get different extra bonuses for being deployed to this war on terror site, and they won't even tell me what they're getting. And I'm gonna stop right there.
Thank you for introducing us and reminding us that there is an entire industry and economy that profits off the detention of these 40 men. When I served as a legal observer there last year, I was really struck by that. It was immediately apparent to me that there's an entire economy there. Also, just as a reminder, when we're thinking about torture, and I think we should call it torture, there was a time where under Department of Defense guidance, torture was defined to only constitute those activities that caused organ failure. That was actually the law of the land for a certain period of time in the United States. So before we go to questions, this is my attempt to just sort of crystallize some of the themes that came together in like 60 seconds. One, we have made progress, and I think it's important to recognize that. 800 detainees have been reduced to 40, and that's progress, and that is the result of advocacy, creative lawyering, the media, and just activism generally. Two, there are very unique challenges we face today, some of which we've heard, whether it's the authorization for the use of military force being interpreted to allow for extended permanent detention absent any kind of due process. the idea that there are lots of competing priorities in this moment. And just general disinterest, as you described it, Carol. How do we get people to actually care about 40 detainees who, in sort of public perception, are 40 of the least sympathetic human beings in the world? And then 3, again, what we still don't know, whether it is the microphones that Rick found, whether it is the torture that we still don't know happened, whether it's the torture that lawyers like Rick know about that we still don't know about. So again, understanding that there is still so much happening at the base today that we can't even really begin to comprehend because it is sort of clouded in a shroud of secrecy. So with that, I want to turn it to questions. I have been asked to ask everyone to use the mic so we can get it on video. And just please try to make your questions brief because we don't have too much time.
Sure. My name's Eileen Jaroslaw. I'm in private practice now, but I was an assistant U.S. attorney in the Eastern District of New York for over 20 years. And I was struck by your question, Sethi, about how do we get the public to care about these 40 men. So I asked myself, why am I here as opposed to in the other room? And honestly, I'm not terribly sympathetic to the 40 men. I'm here because what does it say about us? Who are we? I mean, you know, who are we that we would condone torture to the extent we don't even know about and are okay with the silence? Who are we that we would condone breaching the attorney-client privilege and getting the truth out, and nobody seems to care? I'm really puzzled because I understand that releasing certain intelligence exposes sources and methods, but these people have been here years and years. Those sources and methods are ancient history. Our intelligence services are using different sources and different methods. And we know that when terrorists have been brought to Title III courts, they've been tried fairly, convicted fairly, and sentenced humanely. So to me, the question is, can we change this narrative around what's happening in Guantanamo? What does it say about us as a people, us as a nation, and how can we let this go on in our watch because it is in our name?
Can I just say real quickly, because there's nobody here from what would be considered, if General Martins were here, he would tell you that things are not classified to cover up embarrassing episodes. He would tell you that things are properly classified and that the public has, and that they need to be protected from public scrutiny because of the sources and methods things. But it is increasingly a question one would have to ask, which is perhaps some of it is a national security problem that it is embarrassing. Perhaps some of it is that, I mean, we've seen this with the ACLU legislation, litigation over photos. Disclosing information could have national security consequences because it could enrage people overseas. And so the embarrassing episode, the embarrassing talking point is a little bit more complex than perhaps the general would say. But I do have to represent his position that everything is classified and not to cover up something embarrassing.
Does Congress have the ability to hold hearings if we have a different Congress come next week?
Yes.
They have the ability to hold them now. I mean,
Well, yeah.
I mean, let me just say,
I'm not
though,
sure they-
let me just say that one of the things I think is overlooked, and I think it is about embarrassment. I don't think it has anything to do with sources and methods. The people who were low-level people in the CIA who were doing the torture in 2006 and 2002 through 2006, who've stayed with the CIA, are now upper and middle management. And frankly, they don't want to be facing the consequences of their actions, both in the United States and throughout the world. And I think that's exactly why this stuff still remains classified.
I wanted to just add, with respect, there's the issues with classification, and then there's also, again, this whole body of information about the men and the conditions that has nothing to do with classification, that is just protected, and the government doesn't release for its own reasons. And I think it's because, and I'm thinking of Detainee Artwork, Detainee Artwork. There was an art exhibit at John Jay College in New York last year. It generated a fair amount of media attention, a fair amount of sympathy, because you had representations from the men themselves. It was very humanizing, and it was effective. And as a result, it resulted in a change in GITMO policy in terms of allowing detainees to give artwork to their lawyers, who could then, give it to the media and do things with it, like put on an exhibit. So at that level, to me, again, there's the issue of sources and methods and national security, but it is also, I think, about silencing or concern about the public if they had a certain window or real access to the men, feeling something, being moved to understand that these men are not who the government paints them to be entirely, that there's another side of the story, and that undermining the government's narrative.
Why not move them to Title?
So I want to just stop there and see if there are any more questions in the room. We can take one more.
And can I do a chime in on the artwork? Real quickly, the government position is that they discovered that some of these things were being sold, and they were concerned that the money would get funneled to Al-Qaeda.
We're talking about landscapes.
We can probably do
Paintings of landscape.
two. We'll take them together if there's a second question. I'm trying to be creative. Okay, go ahead, please.
Hi, Bruce Segaris, an attorney here in D.C. Well, one thought for the future is, I think, more litigation, including in the International Criminal Court, which is now, of course, investigating Afghanistan, and more lawsuits overseas with respect to what's going on will help focus the attention of the United States. Because otherwise, I think there will be more indifference, more, for instance, withdrawal from the UN Human Rights Council, etc.
He needs to tell you the Nancy Hollander story.
And then Pardiss, I know you should jump in as well.
Yeah.
Go ahead.
On behalf of Abdul Rahim al-Nashri, 2 cases were brought in the European Court of Human Rights. That is public. You can read the decisions on their website. They're extraordinary decisions that I'm really not allowed to comment on. But the consequences of this, which to me sums up the craziness of Guantanamo, is Nashiri now has been awarded approximately $250,000 from 2 separate countries as damages as a result of the lawsuits brought on his behalf in the European Court of Human Rights. And so there has been litigation, but the litigation doesn't affect what happens in Guantanamo, and that's because of the secrecy.
But one of the attorneys who was a participant in that litigation is no longer allowed to meet with the client at Guantanamo.
Right.
Pardiss, you want to jump in?
Just on the ICC, just doing things internationally on the ICC investigation, it is a really important investigation of Afghanistan, including the U.S. role in war crimes in Afghanistan that we are supporting, CCR supporting, trying to inform. We actually made a really big submission to them, including the profiles of men who are detained in Guantanamo now who suffered abuse in Afghanistan, and I can't say more. And as far as lawsuits at the national level, internationally, we've tried that too. We've brought under universal jurisdiction laws cases that have tried to bring prosecutions or initiate prosecutions against Bush administration officials for their role in torture. That was done in Germany and Spain and Canada. Something we've tried. It's been unsuccessful in court, but it has been important in terms of advocacy.
And so all of you are getting CLE credit for this, and I will look at the camera when I say this. It is the civic duty of every American to watch this panel, to learn from it, and get involved. With that, thank you, everyone.
Thank you.
Thank you.